Back in the saddle again. Hello there, my friend. Welcome back to my channel. I'm so glad to be here. Oh my goodness, I have not been a well person. And I'm glad that today it's worked out because I love doing this, joining with you guys every night, every weeknight, 7:30 p.m. right here on ye old YouTube channel. Did I say this already? My name's Gavin. This is my channel. What we do here is we cover true crime cases, but we like to cut through the fluff. We like to cut through the sensationalism. We really love it when we have documents or we have videos that we can watch. These are the things that we do here, okay? And that's what we're going to do tonight. But let's talk about the case that we're in. I know most of you know this case, but I like to do a little elevator pitch, okay? And boy, am I hoping that my audio is working. I am now just so afraid that it's not. It is. It's working. You guys are okay. And Tamrose says, "Hey Gavin, are you feeling any better?" I'm feeling much better, but I have to show you this. Like, look at my elbow. Look at how red that is compared to like my normal elbow. Neither of them are very fun to look at, but look at that thing. I sometimes have, it's called bursitis, and it's aggravated by things I do. So I went disc golfing with my son, and it aggravated my elbow, and then it just swelled up. It was so painful. And I think what happened was I was taking so much ibuprofen that it was masking how I was actually feeling. And once I got to the point where the pain had gone down enough where I didn't have to take ibuprofen, I stopped taking it, and then the symptoms of having like a flu, just a bug, came out. So I'm feeling much better. Thank you very much for asking. Let's go over, and Lori, thank you. Hope you're feeling better, Gavin. I appreciate that. You guys are awesome. Okay, the case that we're talking about, we have circled back to Madeline Soto. This is a case that's important to a lot of us, right? This is one where the crime is just so egregious and sad. The crime is just so amazingly, and I don't use this word lightly, guys, it's just so evil. This young woman lived through 5 years of hell on earth before her soul was snatched away from this earth. And the man responsible for those 5 years and that last moment, police say, is a man named Stephan Stearns. And I've got a throat lozenge, so I'm sorry that I'm sounding a little spitty tonight. But anyway, Mr. Stearns. Mr. Stearns is the on-again, off-again boyfriend of little Maddie's mother, a woman named Jennifer Soto. Of course, we all have opinions about Jennifer Soto. We're not really going to get into those today. I'm sure that you guys are going to be talking about that maybe in the live chat, but I'm not going to focus on her today. We're going to focus on Mr. Stearns. Now, there are a couple things that have happened in the last day. I probably should have done this. No, this happened this morning, actually, now that I think about it. So let me go to... Where are we going? We're going over to Acrobat, okay? Join me over here on monitor 2. Okay, this document is an order. Oh no, I'm looking at the wrong one. This document is an order of a hearing to be held today at 11:15 a.m. You will remember that Mr. Stearns, through his attorney, made a request to delay a hearing set for tomorrow, and that hearing is set for oral arguments over their motion to suppress certain evidence. And last week, the defense filed a motion going, we've come into some evidence. It's secret evidence. We can't tell you what the evidence is, but we need time to go over this evidence. It might affect our defense. Please, dear judge, dear holy, happy presiding over this case judge, please let us postpone. And the judge goes, let's do a hearing. So they hold that hearing this very morning at 11:15 a.m. in courtroom 4F at 2 Courthouse Square in Kissimmee, Florida. And in this hearing, they are to talk about the motion to continue defense's motion to suppress. It feels like that doesn't make sense, but it does. The defense had a motion to suppress. They then had a motion to continue that motion to suppress. And so they went in front of the judge. Now, fortunately for you and me, this is Florida. And you know what, guys? Oh, dang it. I did not put the channel that this came from. It's a local news channel. I have been on Reddit going back and forth with an old friend of mine that thinks that I'm the devil, apparently. And I didn't take the time to do this. Let me look for it real quick, because I want to give credit where credit is due. Let's see. The video that we are going to watch was titled this. Okay. You'll just pretend that Jeopardy music is going, and I'm going to find it real quick. Okie dokie. Okay. It's WKMG News 6 Orlando. Okay. And why don't I show you their... Oh, I clicked on the channel name instead of the actual video. And we'll go over here so you can see this is the video that we're going to be watching, okay? However, the sound was really bad. And so I downloaded it and I made the sound actual 2 channels instead of just 1. And I amplified it a bit. I didn't change anything, didn't use any AI, didn't do anything like that. I just bumped up the volume so we could hear it a little bit better. That amplifies the noise too, but you guys know how I do, right? All right, so special thanks to WKMG who live streamed this on their channel on YouTube. Now, oh no, that one was from a month ago. The one I just showed you was from a month ago. Let me show you the right one once I can skip this this ad. There we are. Okay, so it is this one. This is the one that we're doing today. It's still WKMG News 6 Orlando. Okay, this is what we're going to watch, but we're going to do it over here for the aforementioned reasons. While we're doing this, I'm going to be taking a look at your comments and probably pausing and discussing along the way if that bothers you because you're new here and you're like, dude, just let me watch it. Tell you what, as soon as we're done here, I'll put a link down in the description to this so that we give credit where credit is due. Sorry that I was working on other stuff, I guess. Okay, here we go. Ready? Hopefully this audio works well too.
We're on the record, State of Florida versus Stephen Michael Stearns, 2024 CF 632. Appearances for the record, please.
Danielle Pinnell and William J. for the state.
And by the way, as audio drops in and out, that is just an artifact of the audio system that they have here. I haven't done anything to engineer this audio. It's not like I'm qualified to do that anyway, other than bump it up a bit. Add the other channel.
Johnson on behalf of Mrs. Stephan Stearns.
Thank you. All right, the court has set this hearing on the defense's motion to continue the suppression hearing, which is currently set for tomorrow afternoon at 2 p.m. Defense, do you wish to present argument with respect to your motion?
Yes, Judge, and defense has a case. I provided a copy to the state already.
Thank you, Susan, for the super chat.
I'm going to give you a moment to read, Judge, or you want me to...
He's going to read it here for a second. Susan goes, the defense won't share the substance of the evidence, even ex parte. What ex parte means is in private, right, to the judge. Not in camera where everybody is there, but ex parte. Anyway, so you're right. You're 100%. And it does not get much traction. Spoiler alert, right? Robin, I do not.
Please
I have
highlight the
her
McKay
cites.
factors.
Essentially, Judge, they all essentially stand for the same
I'm
thing.
good with the McKay factors. Thank you.
And the cases that I provided to the court are Botham v. State, 272 Southern 3rd 876, a 50 CA case from 2019, Turner v. State, 311 Southern 3rd 185, a second DCA case from 2020.
Thanks, Maud.
McKay versus State, first DCA, 504 Southern 2nd 1280 from 1986.
So what
And-
she's doing right now is just telling the judge, here is the case law that I'm using that supports my argument.
Unpublished opinion, but only have the Westlaw site so far. Surratt versus State, 2025, Westlaw 1119091 from last week, from April of 2025. Trocola versus State, 867 Southern 2nd 129, 50 CA from 2004. And Singer versus State, 286 Southern 3rd 343, a 50 CA from 2019. Essentially, Judge, defense is moving to continue the motion to suppress the set for the tomorrow afternoon. And looking at the Bofo case, it essentially says that in moving for a continuance, defense just has to show that we haven't had a reasonable time to investigate or litigate the case, and that is balanced against the judicial economy and judicial efficiency in the court managing their documents, turning to the McKay factors, as well as the factors that are listed in, I believe, Turner, that looks to a defense suffering an injustice by failing to grant the continuance, as well as if the delay was attributable to the defense or if it was unforeseen. Defense would argue that the intention is not to delay the court, isn't to be derelict in our duties. Defense is moving for this continuance based off of, as the court is aware, there is the second case, and preparing for it.
I think she pulls it off, and I think living in Florida, in and around Orlando, I think she pulls it off really well, actually. But I did notice that. Like, are you doing mouse ears in Orlando? Is that what you're doing? And if so, brava. I thought it was awesome.
And preparing for the motion, as well as in preparing the other case for trial, defense is coming to information that at this time the defense isn't in a position to be able to divulge to the court or in open court.
So your good cause is secret?
Essentially, Judge. Well, I can't in good faith at this time, being that it's still being explored. I don't know which way it's going to go, if it's going to be something that's going to pan out in favor of defense or be able to be something to be utilized in this case. As the court is aware, a death notice has been filed in the second case, and while I'm not arguing specifically as to that case, in that death notice, this case is used as one of the aggravating factors. So a conviction on this case would be one of the aggravating factors the state would potentially be seeking in that.
Let's see, Erica, what she was doing is what is required in an oral hearing here. There has to be some sort of precedential case law, something in the common law, something in the statute that would support her argument. So what she's telling the judge, hey, these are the cases that I'm bringing that I believe support my argument. And he'll ask her questions, he'll ask the other side for their argument and so forth. But this is exactly the process. So I honestly, I mean, I'm not rooting for Stephan Stearns here, obviously, right? I've read all of the police documentation that has been made public. We together have watched all the videos. We've listened to the audio. I think the police have a solid case against Mr. Stearns. But I also believe, and I've been taken to task in the comments about this, which I don't mind, but I think that for the next motion, the motion to suppress, I think the defense they're in a good place. For this motion, and so what I'm getting at is I believe that this attorney, I can't remember her name right now, dang it, I need to jot that down, put it on my monitor or something, but I think that she is a competent, good lawyer. But I don't think that she has much of a leg to stand on here. And I've watched this. In fairness, I know what's about to happen. So, and I'm not a lawyer. But anyway, Erica, I hope that helps.
In the death notice in terms of the homicide case, defense would argue that this information has come to light recently, and we're still in the process of working through it and figuring out if it's something that would or wouldn't be available in this case if the defense were to go forward with the motion to suppress at this point. potentially would be relitigated depending on the court's ruling on that. In terms of just regular pretrial in the case, we would going to continue the regular pretrial even aside from the motion to suppress hearing, because we did an evidence viewing. We weren't able to complete the evidence viewing, and the second part of that evidence viewing is scheduled for June 11 with the state in this case. So defense essentially is moving to continue balancing the Botham factors as well as the McKay factors. Defense believes that this isn't a unreasonable request on the court in filing a motion and getting this set for a hearing, and still doing their due diligence in terms of preparing the case otherwise for trial and for the motion to suppress in and of itself.
All right. So the McKay factors, so we're on the same page, deal with a request to continue the trial. The other factors that you mentioned deal with a request to continue either a trial or a
I don't think so, really.
Substantive hearing for absence of a critical witness. State response?
Yes, Your Honor. The state has not been in receipt of any witness list or any defense discovery in this case.
Yeah, let me talk about that. What's funny is I watched this entire thing, but then as we're watching it together, I sometimes miss things that happen because I'm going through that the state of Florida is going to be seeking the DP, the Voldemort word we can't say on YouTube, right? So the penalty, let's call it. So she's bringing that up not necessarily because it applies to this case, because it does not. It applies to the case that they are prosecuting against him for the murder of Madeline Soto. But they're making the murder a capital murder because of the aggravating circumstances that are the 5 years of SA that preceded it. So that's what that means. Great question. You guys always ask the best questions.
Defendant in this case was arrested on February 29th of 2024. The public defender's office was appointed the next day at initial appearances. The discovery process started after the information was filed on March 11th of 2024. The state responded to the defense's demand for discovery on March 20th, 2024, and discovery has been ongoing. The motions to suppress that are currently set for hearing tomorrow were filed by the defense on February 6th of 2025.
Hey guys, about the connection, I apologize. I checked my upload speed and it is really, really low, so I kind of upped the buffer. I'm sorry if it's skipping.
Was a motion to close the courtroom on February 28th of 2025. A notice of hearing for the closure of the courtroom was filed February 24th of 2025. Upon the denial of the defense's motion to close the courtroom on March 27th of 2025, the defense filed a notice of hearing for these motions to suppress. So these have been pending hearing since March 27th of 2025. The defense filed the motions to continue. The defense waited approximately almost 2 months, 2.5 months to request hearing time. The hearing has been set. The state filed responses to the defendant's motions to suppress on April 8th of 2025. And then I was contacted by defense. We had a discussion. State has subpoenaed witnesses. We have a significant amount of hearing time scheduled for tomorrow afternoon. The state's prepared to proceed on the motions and is objecting to the motion to continue the suppression hearings.
Thank you. Any additional argument from the defense?
Yes, Judge. Defense would say that this is necessary for the defense, even if the court were to ask ex parte in terms of to have ex parte hearing in terms of the basis for the motion. I don't believe at this point defense will be able to disclose that information even to the court, even if an ex parte hearing were requested and or granted. It's defense's position that this information is necessary to be explored in terms of it's necessary to be explored in terms of the presentation of the evidence or presentation of the case, because it's defense's position that at this time the information is confidential, which is why a witness list hasn't been disclosed, discovery exhibits haven't been disclosed in regards to it, because it's still being looked to and explored. As the state indicated, discovery is ongoing, and as discovery has continued to be ongoing, so has defense's preparation of the case, reviewing of the motions, filing of the motions, preparation of the motion, as well as in preparing this case otherwise for trial alongside the homicide case. So it's defense's position that the granting of the continuance in this case would not be an undue burden on the court. I understand the state having subpoenaed witnesses. The day that I found out about the information was the same day we actually happened to have sent about it, and then sent her an email in regards to her position, and then from there filed the motion to continue. And then we got hearing times while I was in trial with Your Honor as another case, and I filed a notice of hearing as to that. Defense has been preparing, defense is preparing, and it's defense's position that denial of the motion to continue in this case would be an abuse of discretion, and we'd be asking the court to grant the requested continuance.
Thanks. Well, the court's in a difficult position evaluating the McKay factors. In this case, the court's going to find that there has been significant time to prepare for these hearings. This case initiated in February of 2024. Motion was filed almost a year later. The matter was set for a hearing in March, 13 months. I'll note that this is on 24 CF 632. While the two cases are related, this does not deal with the homicide case. The court has an inability to make a determination as to the likelihood of prejudice from the denial. The defense apparently is in possession of some information, the nature of that information, the timing of when it was received, whether the defendant played any role in shortening the preparation time. The availability of that discovery is unknown to the court because the defense is unwilling at this point to share any information with the court, even on an ex parte basis, as to this information. Counsel that has been appointed to this case has the requisite skill and experience to try this type of case. Both are either board certified criminal trial experts or in the process of becoming are being certified as a criminal trial expert. The court cannot, from the information presented, make a finding of good cause, and while the defense argues it will be prejudicial, there's been nothing advanced to the court to support that argument. So the defense's motion to continue the motion to suppress tomorrow, scheduled for 2 p.m., is denied. And I'll ask the state to please have their witnesses present and ready to go.
No problem.
Thank you. Matter set for 3 hours tomorrow at 2 p.m.
All right, so that is the end of the hearing. Man, I'm so sorry that the internet connection is so bad at my house right now. I think it's in the whole area. So I'm going to keep this very brief, and then I'm going to upload it later so you guys can see the whole thing, okay? Let me bring you over to Acrobat real quick. And here, what we can see here is that there is now an order to appear tomorrow at 2 p.m. for the hearing that was previously ordered. There is still an order for a jury trial on May 5th. That's never going to happen. We all know inside baseball that's never going to happen. With that, guys, I'm so sorry the technology is failing us today, and I'm back and I'm feeling good and everything. It's just a bummer that technology is failing us, but I will try to make it right by uploading another copy of this. I'll link to it in the description below once I get it uploaded. And then we will, hopefully I'll be able to address my internet connection with the old internet service provider, so that when we join one another again tomorrow at 7:30 Eastern, 7:30 p.m. Eastern time, we won't have these same problems. All right. Thanks for being so patient. It's a real bummer, but I will see you on the next one. All right. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.